In the Court of Appeals, 8th Judicial District, Cuyahoga County, Ohio. Carrington Mortgage Services, LLC. Plaintiff Appellee, B.S. Princess Ada Israel. Defendant Appellant. Appeal No. CA 25-115296. Trial No. CV 24-999054. On appeal from the Cuyahoga County Court of Common Pleas. Brief of Defendant Appellant Princess Ada Israel. Tamara E. Gurchik, 009-0798, Princess Ada Israel. 4805 Montgomery Road 4364, Western Center Boulevard. Suite 320 Suite 5077. Norwood, Ohio 45212 Fort Worth, Texas 76137. 513-396-8100303, 552-3777. tgurchik@logs.com 2591 Lee Road @gmail.com. Attorney for POSI. Carrington Mortgage Services LLC. 1600 South Douglas Road Suite 200A. Anaheim, California 92806. Table of Contents. Table of Authorities, 3-4. Statement of Assignment of Errors, 4-5. Statement of the Issues for Review, 5. Statement of the Case, 6-7. Statement of the Facts, 7. Law and Argument, 7. Assignment of Error, 7-8. Assignment of Error, 8-9. Assignment of Error, 9-10. Assignment of Error, 10-13. Assignment of Error, 13-15. Assignment of Error, 15-16. Assignment of Error, 16-19. Assignment of Error, 19-24. Conclusion, 24-28. Certificate of Services, 29. Appendix, 30. 2 Table of Authorities. Constitutions, Codes, and Rules. Constitution of the State of Ohio Article 1-1, 8. Constitution of the State of Ohio Article 116, 8-22-23-24. Ohio Code of Judicial Conduct Rule 2.2, A. 9-20-20-22-24. Ohio Code of Judicial Conduct Rule 2.3, A, B, 9-20-20-22-23-25. Ohio Code of Judicial Conduct Rule 2.6, A, 9-20-20-22-23-25. Ohio Revised Code Title 7 Chapter 715 715.03, 16. Ohio Rules of Civil Procedure Rule 1, B, 17. Ohio Rules of Civil Procedure Rule 12, A, 1, 8. Ohio Rules of Civil Procedure Rule 19, A, 1, 16. Ohio Rules of Civil Procedure Rule 4.3, B, 1, 2, 12. Ohio Rules of Civil Procedure Rule 4.4, A, 1, 11,12. Ohio Rules of Civil Procedure Rule 55, A, 7,20. Ohio Rules of Civil Procedure Rule 6, A, C, 1, 16. United States Constitution 14th Amendment 1, 8,12, 17, 21. Cleveland Heights Codified Ordinances. Chapter 1329 Point of Sale Inspection, POSI, 13,25. 1329.01, A. Certificate of Inspection Required, 14. 1329.03, A, B, Compliance Documents, 14. 1329.05, A, B, G, Required Use of Certificate of Inspection, 14. 1329.06 escrow agent obligations, 14. 1329.99 and 1311.99 penalty, 15. Case. Mullane vs. Central Hanover Bank and Trust Company 339 U.S. 306, 1950, 12. Websites: www.2591leroad.com, www.2591leroad.org, www.allknowchualnerwelcome.com, www.allknowchualnerwelcome.org, www.posohio.org, www.pointofsaleinspection.org, www.pointofsaleinspection.com, www.robinhood666.com, www.wegothetruthhandtheproof.com, www.princessadaisrael.com. Plaintiff Appellee Carrington Mortgage Services, LLC, CMS. Defendant Appellant Princess Ada Israel, Ms. Israel. 3. Statement of Assignment of Errors. Statement of Assignment of Error 1. A default judgment was granted against Ms. Israel, who filed a timely answer and was ready to defend her position. Default judgment is for parties that do not answer the complaint. Statement of Assignment of Error 2. The trial court failed to answer motion to grant Ms. Israel's attendance via telephone for default hearing or include court telephone number. Statement of Assignment of Error 3. The trial court ruled, in part, for default judgment because the unknown spouse of Princess Ada Israel did not object to the claims. Statement of Assignment of Error 4. Attorney Gurchik failed to notify Ms. Israel, at her known forwarding address provided to loan servicer prior to complaint filed. Statement of Assignment of Error 5. Cleveland Heights Point of Sale Inspection, POSI, City Ordinance was not executed for the February 14, 2020 transfer. Statement of Assignment of Error 6. Attorney Gurchik failed to join the necessary parties. Relief cannot be granted from Ms. Israel. Assignment of Error 7. Throughout the proceedings, motions were not answered within 14 days or not answered due to the case was closed abruptly after the order for sale. Assignment of Error 8. Same type of case, same loan servicer, same attorney, same courthouse, different judges/magistrates with irregularities in the 2 foreclosure proceedings. 4. Statement of the issues for review. Issue 1. Whether the trial court erred by entering a default judgment against Ms. Israel. She was served on August 07, 2024 and filed a timely responsive answer within 15 days on August 22, 2024. Issue 2. Whether the trial court erred by not answering Ms. Israel's motion filed on November 21, 2024. She requested appearance via telephone for default judgment hearing. Issue 3. Whether the trial court erred by including this statement in the default judgment decision to grant, in part, defendant unknown spouse, if any of Princess Ada Israel is in default of answer or other pleadings and thereby confess the allegations of the complaint to be true. Issue 4. Whether the trial court erred, after Ms. Israel informed the court she was not served at her known forwarding address and failed to dismiss the case for improper service. Issue 5. Whether the trial court erred to exclude evidence submitted by Ms. Israel in regards to fraud, avoided transfer and failure to comply with city ordinance transfer. Issue 6. Whether the trial court erred by allowing attorney Gurchik to place an unenforceable mortgage on Ms. Israel, when the sellers were the recipients of the loan and failed to transfer the property, in accordance to the city ordinance. Issue 7. Whether the trial court erred in answering motions in a timely manner. Issue 8. Whether the trial court erred in giving the appearance of bias with intentional delays, denial of participation, granted default judgment, waited 6 months to give the order for sale and abruptly closed the case afterwards. B. Statement of the case. This case main concerns are the transfer of title, if it was valid, or avoid transfer. The City of Cleveland Heights has in place a POSI that is required for real estate transfer. Prior owners of 2591 Lee Road, Cleveland Heights, Ohio 44118 has on city record an executed acknowledgement form prior to closing, a POSI and a letter of transfer from the city. The property supposedly transferred to Ms. Israel February 14, 2020, without the above documents executed. In addition, the property had excessive concealed major repairs from day one, after closing. The 2020 COVID pandemic, VA moratorium from March 2020 to September 2021, a one-year forbearance October 2021 through October 2022, 2 loan modifications October 2022 through March 2023, a 90-day wait March through June 2023, demand letter sent by attorney June 2023, loan servicer transferred the loan August 01, 2023, CMS waited until the last week of November 2023, to inform Ms. Israel December 01, 2023 through May 31, 2024 the VA moratorium halted the foreclosure for veterans. This moratorium was allocated to veterans who wanted to keep their home. Ms. Israel was approved for an expedited foreclosure March 2023, the first loan servicer claimed they would proceed with foreclosure. Ms. Israel was forced out of the property with death threats, investors' harassment, and deplorable conditions of the property February 21, 2024. The property, now vacant, CMS can file foreclosure under the VA Vacant Property Protocol. CMS waited until June 17, 2024 to file the complaint. On June 13, 2024 Ms. Israel's computer was hacked and only the Ohio files were destroyed. Unknown persons tried to murder her while renting a warehouse unit May 2024 through August 2024. The process server and certified mail for the complaint were served at the vacant property, with full knowledge of Ms. Israel's forwarding address. Ms. Israel was notified by a stranger that the property was on the docket by a text message. The default judgment was granted without Ms. Israel's presence at the default hearing and a 6-month delay to order the property for sale. Due to questionable actions with this foreclosure proceedings, Ms. Israel filed an appeal. 6. Statement of the facts. The POSI is required for all real estate transfer unless it is gifted to a family member. Former owners utilized the POSI to transfer the property. Upon the transfer for Ms. Israel, the requirements were non-existent. After the questionable transfer, the POSI would resume enforcement. If Ms. Israel wanted to sell the property, she would need to comply with the POSI. CMS filed a bogus foreclosure knowingly upon the wrong defendant. Mr. and Mrs. Johnson of JJ Real Estate Solutions, LLC are the owners and they received the $232,500 check, therefore they are in default. Ms. Israel is the victim of fraudulent circumstances in a sophisticated housing scheme by professionals in the real estate industry and city officials. United Wholesale Mortgage, UWM, transferred the loan, knowing it was a defective title. CMS lawsuit is with UWM and those who cashed the check and failed to transfer a valid title. Over the years, Ms. Israel published websites that contain the files of the transfer, city files with the history of the POSI, former owners, and years of harassment and scare tactics to force her to sell the property. She has not been sued by anyone because it is the truth. 7. Law and argument. Assignment of error. A Ohio Civil Rule 55. A default judgment is available when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend. Key phrase, failed to plead. Ms. Israel filed her answer on August 22, 2024 after receiving her complaint via certified mail on August 07, 2024. Ohio Civil Rule 12. A. 1. Ms. Israel answered and filed with the court within 15 days, and pre-answered her defenses. The loan was not hers due to mortgage fraud. Assignment of error. B. 14th Amendment, Due Process, and Ohio Constitution Article 1:16. Ms. Israel's written motion created a due process right and the court denied her inalienable rights and the right to participation, justice administered without denial or delay. Under Ohio Civil Rule 6, A, C, 1, the court failed to notify Ms. Israel within 14 days, after she filed her motion. Instead, the court called her on the day of the hearing, that went to voicemail. On November 08, 2024, Attorney Gurjic filed a default judgment and summary judgment that were answered on November 19, 2024. The trial court scheduled the default judgment hearing on November 19, 2024, for the hearing on December 12, 2024 within 17 days excluding weekends and Thanksgiving, a total of 24 days. According to the CCCP docket CV 24 to 994,394, the magistrate included a court telephone number with the default hearing time and date. The trial court's decision entry was posted without the attachment on December 18, 2024. Attorney Gurjic received an email. A letter was mailed to the unknown spouse in Texas, December 19, 2024, while Ms. Israel received no email. A letter mailed to her Texas address and a letter addressed to Ms. Israel at the vacant property address on December 27, 2024. The order of the sale was July 03, 2025. Ms. Israel did not receive email notification even though the docket shows an email was sent. Ms. Israel learned the case was inactive on July 03, 2025 after she filed her motion. The property was ordered for sale and the case becomes inactive/closed is not how the CCCP docket CV 24 to 994,394 showed the default judgment, order of sale of the property. A series of transactions transpired to sell the property. Based on motions filed in November 2024, pertaining to the default judgment, the exclusion of Ms. Israel at the default hearing, excluded from email notification on December 18, 2024 and delayed mail notification, it appears the trial court did not perform all duties fairly and impartially and gave the appearance of bias, failed to give the opportunity to be heard, when it came to answering Ms. Israel's motion in a timely manner, to attend the default judgment hearing, granted the default judgment and notifying Ms. Israel of the decision. Ohio Code of Judicial Conduct Rule 2.2, A, 2.3, A, B, 2.6, A. Assignment of error. See a lawyer names an unknown spouse when the borrower's marital status is unknown but is not on the deed. Ms. Israel filed her motion on June 20, 2024 to remove the unknown spouse, confessed that she was not married at the time of the loan or before the filing of foreclosure or present. Verification from Ms. Israel should have removed the unknown spouse. On July 15, 2024, the trial court denied motion stating Defendant Princess Ada Israel's motion not to serve spouse or unknown spouse is denied. This is the plaintiff's complaint and the plaintiff will determine at time the service stage of the litigation, what parties to name, serve, or dismiss. There are no licenses for unmarried persons. Ms. Israel stated on her loan documents she was not married and not currently married. This was all the proof needed to remove the unknown spouse. It is used when the name and location of the spouse is unknown. The unknown spouse was conveniently used in part to grant the default hearing because they did not answer. A fictitious character was used in an actual case to render in part of an actual default judgment. As of this filing, Ms. Israel's marital status remains not married. The court's reliance on an alleged unknown spouse who failed to respond is legally irrelevant to Ms. Israel's defense and constitutes a fundamental misapplication of Ohio Rules of Civil Procedures. Assignment of error. D. January 2024, notice of intent to sue was sent to Carrington Mortgage Services, LLC, CMS, with the Livingston, Texas forwarding address. February 14, 2024, attorney Kara A. Zanuck, for CMS responded, sent a letter to the Livingston, Texas address, followed by an email with a copy of the letter. February 14, 2024, Ms. Israel responded to CMS attorney with corrections to the address. June 20, 2024, attorney Gurjic sent a process server to the property address and mailed certified letters to the property address on June 21, 2024. that was monitored by CMS and known to be vacant, and after Ms. Israel filed a motion on June 20, 2024. June 21, 2024, Ms. Israel filed motion to be served at her current Fort Worth, Texas address. Motion was unopposed and granted on July 15, 2024. July 25, 2024, Attorney Gurchik sent certified letter to the Fort Worth address. Ms. Israel received certified letter August 07, 2024. August 19, 2024, for unknown reasons, Attorney Gurchik paid for service by publication after Ms. Israel received the certified letter on August 07, 2024. Attorney Gurchik allegedly engaged in a pattern of intentional improper service designed to obtain a quick default judgment. Despite actively monitoring the Ohio vacant property, charging monthly fees, CMS filed a bogus insurance claim for frozen pipes around May 2024. The insurance company notified Ms. Israel at the Livingston, Texas address, afterward denied the claim and canceled the policy. After service was achieved via certified mail on August 7, 2024, two motions filed prior, by Ms. Israel, Attorney Christopher G. Phillips, file an affidavit with the trial court claimed on August 19, 2024, summons cannot be made upon the defendants Princess Ada Israel and unknown spouse, if any of Princess Ada Israel, defendants' identities are unknown or the residence of said defendants. Service was attempted by process server and certified mail, which failed. This conduct violates Ohio Civil Rule 4.4, A.1, constitutes bad faith, manipulation of service procedures in violation of constitutional due process. In hindsight, this was the setup to obtain the default judgment, hence, she was not included at the in-person hearing because they can't locate her and she did not answer her phone. This is an alleged foul fraud, snaking its way through the court because they all know, this is avoided transfer and the mortgage is unenforceable upon Ms. Israel or the unknown spouse. This is why, the delays were manufactured for years to run down the statute of limitations. This is why, the loan servicer persuaded Ms. Israel to take the 1-year forbearance to accumulate late payments. This is why she is chased and stalked around the country to keep her distracted and possibly murdered on the streets. This is why, they have intentionally damaged her credit to keep her homeless, so that a publication can be filed to obtain a default judgment. Ohio Civil Rule 4.3, B. 1, 2. Process for out-of-state service was not utilized upon initial attempt to serve Ms. Israel. CMS knew the Livingston, Texas address around January 2024 and chose to serve a vacant property by process server and certified mail. Sending the notices of foreclosure to a vacant Ohio property was intentionally improper. Ohio Civil Rule 4.4, A.1. Service by publication is the last resort method for locating a defendant when address is unknown. CMS knew the Livingston, Texas address for months prior and Ms. Israel filed motions prior to the publication. The publication on August 19, 2024 was filed after 11 days elapse, after successful service on August 07, 2024 to both Ms. Israel and unknown spouse on the docket entry. The suite number on the address, to the unknown spouse, was excluded, to generate a failure of service on July 31, 2024 on the docket entry to later file a false publication upon Ms. Israel and the unknown spouse. 14th Amendment Due Process Right to Notice and Be Heard. Mullane v. Central Harbor Bank and Trust Company, 339 U.S. 306, 1950, ruled the court established that due process requires a method of notice that is reasonably calculated, under all circumstance, to apprise interested parties of the pendency of the action and afford them an opportunity to present their objection. If a party's address is known, notice must be sent to that address. The notice of service was not reasonably calculated. CMS was aware of the address and made a choice not to notify Ms. Israel to obtain a default judgment on avoided transfer. Bad faith evidence. CMS charges a monthly fee to monitor the vacant property, proved knowledge of vacancy. May 2024, CMS filed a bogus insurance claim for frozen pipes on Ms. Israel's homeowner's insurance proved again CMS had access to the inside of the vacant property. CMS attorney responded to the Livingston, Texas address on February 14, 2024, proved again, they had full knowledge of Ms. Israel's current address when the complaint was filed June 17, 2024. Attorney Gurchik sent a process server to a known vacant property on June 20, 2024 followed by certified mail on June 21, 2024. No process server or certified mail were sent to the Livingston, Texas address. Assignment of error, E. To legally foreclose on a property, the foreclosing bank needs a valid title. Ms. Israel was fraudulently induced in a defective purchase and the bank seeks to foreclose on a property she never legally acquired. The underlying transaction that violated Cleveland Heights Codified Ordinance Chapter 1329 rendering transfer voidable. Ms. Israel never executed the required acknowledgement form, never received a copy of the point of sale inspection, POSI, and the city never approved the transfer before executing the loan documents. The sellers intentionally concealed major repairs with the help of the inspectors who made claims the property had no major defects. The appraiser inflated the value and sellers/realtors and title company withheld the inspection report. Without valid title transfer, CMS lacks legal capacity to foreclose upon and mortgage is unenforceable. Cleveland Heights Point of Sale Ordinance Requirements Chapter 1329 Point of Sale Inspection, POSI. Before a seller can place their property on the market, they must pay a fee to have an inspection performed, to obtain from the Commissioner of Building Inspection a certificate of inspection and present such certificate to prospective buyers or grantee prior to entering a purchase agreement in order to permit the escrow agent to comply. December 30, 2019, the city informed the sellers to give a copy of the POSI and execute the acknowledgement form, 1329.01, a certificate of inspection required. Ms. Israel did not receive a copy of the certificate of inspections that listed pertinent information in making a fair offer. At the request of the seller or title, the city may issue a letter that the violations were completed or not. 1329.03, a, b, compliance documents. The inspection certificate is a requirement, not an option, to provide the purchaser or prospective buyers with the current certificate. The seller is under obligation to obtain an executed acknowledgement form that acknowledges the buyer have received a copy. Ms. Israel did not execute an acknowledgement form between January 08, 2020, purchase offer, during closing, or on February 13, 2020 during the signing of the loan documents. The only option to avoid this is through inheritance of gift with no bona fide sale. Ms. Israel is not related to the sellers, nor was it a gift, because there was a $232,500, $232,500 check that exchanged money for property. 1329.05, a, b, g, required use of certificate of inspection. Escrow companies in Cuyahoga County and the state of Ohio have a list of all the cities and towns that require approval to transfer property. Under 1329.06 escrow agent obligations, an escrow agent cannot disperse funds or transfer property unless they comply with the provision of Chapter 1329. Ms. Israel called about a dozen title companies to inquire what was needed to transfer property in Cleveland Heights. All of them stated a current POSI, an executed acknowledgement form from the buyer, and they would acquire the approval letter from Cleveland Heights to transfer the title. Apparently this is the legal way to transfer a title to secure a mortgage. Fidelity National Title knew the documents were not included in the closing packet. By concealing the documents from Ms. Israel during closing, it voided the transfer and the loan. Therefore, Ms. Israel is not the owner of the property or owe any debt. The penalty of a $1,000 fine and or 6 months in jail statute of limitations expired February 14, 2021. That the city could impose $1,329.99 and $1,311.99 penalty. Because the city chose not to persecute, does not make the transfer legal and binding with the loan documents, it makes them party to conspiracy, mortgage fraud and select code enforcement. The February 14, 2020 transfer was legally void ab initio for failure to comply with Cleveland Heights City Ordinance with Chapter 1329. A chain of title defect voids the acquisition, made the mortgage unenforceable against the property. Around April 10, 2019, Mr. and Mrs. Jenks found a buyer to purchase the property. They have an inspection and showed the POSI to the potential buyer, who aborts the sale for unknown reasons. Months passed. Mr. Jeremiah Johnson, house flipper co-owner, sign an acknowledgement form July 29, 2019, and the escrow company receive a letter of approval on July 31, 2019 to transfer the property. Cleveland Heights property owners, for decades, have transferred property to secure their mortgage with a valid title, using the POSI. If not, former owners could reclaim the property under a voided title. Cleveland Heights has clear authority under the Ohio Revised Code Chapter 715.03 powers by ordinance or resolution by established ordinances that controls the transfer of real estate in the city of Cleveland Heights. The transfer is void because Ms. Israel never had legal title, never had authority to mortgage the property, and the foreclosure is against the wrong party. Assignment of error. F. Ms. Israel's defense involves third-party conduct. Complete relief cannot be granted. Without those parties, there is a risk of inconsistent judgments. Ohio Civ R. 19a. Not ensuring joinder of the necessary parties whose conduct is central to Ms. Israel's defense by not executing an acknowledgement form or receiving a copy of the POSI. Ms. Israel relocated from the state of California, bought and sold property in California and several other states, and never encountered a POSI. She had no clue of the proper procedures to transfer property in Cleveland Heights, Ohio. She retained a licensed realtor, Tanisha Speed, Ms. Speed. During the same time, Ms. Speed sold another buyer a property in Cleveland Heights who executed their acknowledgement form weeks prior to closing. The collective conduct and actions of the sellers, realtors, title company, loan company, inspectors, VA appraiser, first loan servicer and the city of Cleveland Heights made it possible to void transfer of the property and obtain $232,500 by their collective authority, positions and powers. Ms. Israel relied on a group of white-collar professionals to perform their obligated duties, to transfer the property, to legally to obtain a mortgage. Assignment of error, G. In 2019, Ohio Civ R. 6, C. 1, was amended to create more consistent and specific deadlines for motions in civil actions across Ohio. Responses are due within 14 days and no replies are not permitted. There were 23 combined motions filed. 2 were answered within 14 days, 2 were answered on the 14th day, 4 were not answered, and 15 motions exceeded 14 days response time, of which 5 exceeded 100 days response. The systematic delays failed to obtain just results. Ohio Civ R1, B. Due process violation of the 14th Amendment that allows for equal protection and procedural due process and requires fair procedures. Unfortunately, Ms. Israel do not have the resources, stable internet, and time to present all the errors that were judicial conduct violations. Timeline and response time of motions. Ms. Israel believes her motions were not answered in a timely manner and with bias. Days calculated exclude holidays and weekends, Saturday, Sunday. Below are the motions filed, a total of 23 motions. Attorney Gurjik filed 3 motions and Ms. Israel filed 20 motions. June 20, 2024, Ms. Israel 1 not to serve spouse or unknown party. July 15, 2024 denied answered, 16 days. June 21, 2024 Ms. Israel 2 change of defendant's mailing address. July 15, 2024 unopposed and granted answered, 15 days. July 12, 2024 Ms. Israel 3 requests service via certified mail. September 11, 2024 moot answered, 43 days. September 20, 2024 Ms. Israel cease all actions until VA loan is notified. October 21, 2024 denied answered, 20 days. September 26, 2024 Ms. Israel 5 withdraw cease all actions until VA loan is notified. October 21, 2024 denied answered, 16 days. November 08, 2024-1 Attorney Gurchik default judgment motion for default judgment. November 19, 2024 default judgment set for hearing on December 12, 2024 at 10:30 a.m. Answered, 6 days. November 15, 2024 Ms. Israel 6 error on payments. December 12, 2024 denied answered 18 days. November 21, 2024 Ms. Israel 7 telephone hearing. December 12, 2024 moot answered 14 days. November 21, 2024 Ms. Israel 8 telephone request amended _font added note December 12, 2024 denied moot filed twice answered 14 days. December 01, 2024 Ms. Israel 9 remove Princess Ada Israel photos and description from Zillow December 12, 2024 denied the court does not have jurisdiction over Zillow in this case. Answered, 9 days. December 29, 2024 Ms. Israel 10 to set aside magistrate judge order December 18, 2024. June 24, 2025 moot answered, 122 days. December 31, 2024 Ms. Israel 11 alleged judicial discrimination and failure to report mortgage fraud. June 24, 2025 not well taken overruled answered, 122 days. January 05, 2025 Ms. Israel 12 error on docket 12/27/2024 D1 and D2 recap. June 24, 2025 not well taken overruled. Answered, 115 days. January 07, 2025 Attorney Gurchik 2 plaintiff motion to strike defendant's motion to set aside magistrate decision. June 24, 2025 answered, 115 days. January 17, 2025 Ms. Israel 13 to expedite order to sale. June 24, 2025 unopposed and granted answered 109 days. May 28, 2025 Attorney Gurchik 3 for rulings. July 03, 2025 order adopting the magistrate decision. Answered, 27 days. June 24, 2025 Ms. Israel 14 change of phone number objection to entire foreclosure proceedings. July 15, 2025 unknown answered, 22 days. June 24, 2025 Ms. Israel 15 to dismiss dismissal on the grounds of frauds. July 15, 2025 unknown answered 22 days. June 26, 2025 Ms. Israel 16 to dismiss filed amended motion on the grounds of frauds. July 15, 2025 unknown answered, 22 days. On July 3, 2025 Ms. Israel filed her motion first on the docket for that day. Questionable actions occurred that placed magistrate's decision in front of her motion and closed the case. July 03, 2025 Ms. Israel 17 unlawful restraint attempted murder conspiracy. No response. July 04, 2025 Ms. Israel 18 amended motion to unlawful restraint attempted murder conspiracy. No response. July 06, 2025 Ms. Israel 19 serve court order 07032025 via email due to flooding. No response. Note: the order was not visible on the court website on July 03, 2025 until July 07, 2025, after the clerk emailed Ms. Israel a copy around 6:54 a.m. If it was available on the court's website on June 03, 2025, Ms. Israel would not need to file a motion, Due to mail service interruptions caused by the Texas flooding, Ms. Israel requested the order to be sent via email. July 15, 2025 Ms. Israel 20 Stay of foreclosure proceedings, stay of distribution of sale. No response. Assignment of error. H. For purposes of comparing differential foreclosure procedures, there are entries made on the dockets that raises questions in fairness and due process. Attorney Gurchik filed 2 foreclosures, with different judges/magistrates. Both of defendants filed appeals. Christian Avoits, Mr. Avoits, and Ms. Israel both claimed they were not served their complaints. Mr. Avoits did not file an answer. That prompted Attorney Gurchik to file a default judgment. Ms. Israel filed an answer, raised claims of mortgage fraud. The trial court instructed Attorney Gurchik on October 28, 2024 to file her papers for default judgment against Ms. Israel. Ohio Civil Rule 55A is triggered if a party fails to answer the complaint or failure to defend. Ms. Israel answered the complaint with questionable transfer of title, defense. At all times a judge should be impartial and fair according to Ohio Code of Judicial Conduct Rule 2.2a. Refrain from bias actions according to Ohio Code of Judicial Conduct Rule 2.3a, b, and ensure that all parties are given the right to be heard according to Ohio Code of Judicial Conduct Rule 2.6a. This is the default judgment hearing. Excerpt of the docket entry for Mr. Avoits, who resided in Euclid, Ohio, May 7, 2024 N/AMG. Telephone default hearing set for July 16, 2024 at 3 p.m. Any party may appear at the telephone default hearing by calling 216-443 10 minutes prior to the scheduled time of the hearing. The party moving for default judgment must send notice to all parties of the default hearing at least 7 days prior to the hearing. This notice must provide the call-in information above. Failure to appear at default hearing may result in dismissal of the case. This hearing may be attended only via telephone. Notice issued. This is the default judgment hearing. Excerpt of the docket entry for Ms. Israel, who resided in Fort Worth, Texas. November 19, 2024 MG motion for default judgment is set for hearing on December 12, 2024 at 10:30 a.m. before Magistrate Amy R. Jackson, 310 W Lakeside 6 THFL, located across the street from the Justice Center on the northwest corner of Lakeside Avenue and West 3rd Street. The moving party must send notice of the date and time of this hearing and a copy of this motion to all parties, including those who have yet to enter an appearance, at least 14 days in advance of the hearing. Failure to may result in a dismissal of the claims or an entry of judgment. Notice issued. The magistrate scheduled an in-person hearing for an out-of-state homeless, pro-se litigant expected to attend a default judgment hearing, in person. A magistrate scheduled a telephone hearing for a defendant 12 miles away. The in-person hearing was scheduled for a defendant 1,200 miles away for a default judgment hearing. This right here is where Magistrate Amy R. Jackson sent a personal message to Ms. Israel that she had one objective: to grant default judgment to CMS by any and all means possible. The magistrate failed to include a court telephone number. That prompted Ms. Israel to file a motion to appear via telephone, who wanted to present her defense. By not including a phone number or answering the motion, denied Ms. Israel due process under the 14th Amendment. At all times a judge should be impartial and fair according to Ohio Code of Judicial Conduct Rule 2.2a. Refrain from bias actions according to Ohio Code of Judicial Conduct Rule 2.3a, b, and ensure that all parties are given the right to be heard according to Ohio Code of Judicial Conduct Rule 2.6a. After the hearing, the docket entry showed the trial court acted on no-show for Mr. Avoits. July 18, 2024 N/AMG default hearing held by magistrate on July 16, 24. Plaintiff's counsel appeared. Defendant, S, did not appear. Plaintiff's motion for default judgment is granted. The magistrate will issue a magistrate's decision making specific findings as to the rights and liabilities of the parties. Notice issued. After the hearing, the docket entry showed trial court acted on no-show for Ms. Israel. December 12, 2024 N/AMG default hearing held by magistrate. Counsel for plaintiff appeared. This matter was scheduled as an in-person hearing. Defendant Israel filed a motion to appear by phone. The magistrate called the defendant at 10:30 a.m., the time of the hearing, and defendant did not answer. Defendant Israel filed an answer, and as such, the motion for default was not as to her and was only as to the John Doe unknown spouse of Princess Ada Israel. A ruling on the motion for default as to the John Doe unknown spouse of Princess Ada Israel and the plaintiff's motion for summary judgment will be made in a magistrate's decision that will be issued forthwith. Notice issued. Based on the actions of the magistrate, apparently, the unknown spouse attended the hearing and did not object. Ms. Israel was systematically, intentionally denied from the default hearing by not including a court telephone number with the notice of the hearing, failing to answer her motion, and not including a callback number with the voicemail left on the day of the hearing. This violates Ohio Constitution Article 116, justice administered without denial or delay. At all times a judge should be impartial and fair according to Ohio Code of Judicial Conduct Rule 2.2, a. Refrain from bias actions according to Ohio Code of Judicial Conduct Rule 2.3, a. b. And ensure that all parties are given the right to be heard according to Ohio Code of Judicial Conduct Rule 2.6, a. On July 19, 2024, the magistrate's decision was completed. Emails were sent the same day to the attorneys, Mr. Aboitz, and the unknown spouse were mailed on July 23, 2024 to the property address. On December 18, 2024 the magistrate's decision was completed. Emails for the attorneys were sent the same day. The unknown spouse for Princess Ada Israel was mailed to the Texas address on December 19, 2024. A copy was mailed to Ms. Israel's Texas address and a copy was sent to the Ohio vacant property for the unknown spouse on December 27, 2024. The trial court failed to include Ms. Israel in email notification. As a pro-se litigant, her email was included in court notification, prior to and resumed after Ms. Israel filed motions on December 29, 2024 until July 17, 2025 last filing. The default judgment hearing showed a pattern of the magistrate intentionally excluded Ms. Israel from participating and delayed sending her a copy of the decision. This violates Ohio Constitution Article 116, justice administered without denial or delay. At all times a judge should be impartial and fair according to Ohio Code of Judicial Conduct Rule 2.2, a. Refrain from bias actions according to Ohio Code of Judicial Conduct Rule 2.3, a. b. And ensure that all parties are given the right to be heard according to Ohio Code of Judicial Conduct Rule 2.6, a. After the hearing notifications, from August 14, 2024 through November 04, 2024 the property of Mr. Aboitz went from adopting the magistrate's decision to the auction final sale and judgment. All actions were noted in the entry that ultimately sold the property. After the hearing notifications, from December 18, 2024 through July 03, 2025 the magistrate entered the order of adoption for sale and closed the case. Despite the fact, Ms. Israel filed a motion to expedite the order of sale in January 17, 2025, the trial court was aware Ms. Israel was homeless and chose not to expedite the sale of the property. This violates Ohio Constitution Article 116, justice administered without denial or delay. It's also noted that Mr. Aboit's appeal docket showed a certified copy of his transcript within days of filing the appeal on May 28, 2025. June 25, 2025 Appellant's 911-5174 record transmitted to the Court of Appeals consisting of the certified copy of the docket, journal entries, and the original papers on CA No. 115,174. On the docket for Ms. Israel July 28, 2025 showed the transcript was sent to the appeals court. The appeals court noted there were no records submitted. July 28, 2025 P1D1 CASR Appellant's 911 5296 record transmitted to the Court of Appeals consisting of the certified copy of the docket, journal entries, and the original papers on CA No. 115,296. The final straw on the camel's back. After 100+ days of silence, the magistrate closed the foreclosure case on July 03, 2025 and have yet to answer any motions filed afterwards. This is irregular to the procedures of foreclosure. This foreclosure encountered intentional delays by the loan servicers and now the trial court because Ms. Israel answered the foreclosure. If not for the stranger, who sent Ms. Israel the text message, this property would have sold by December 2024. The entire foreclosure violated Ohio Constitution Article 116, justice administered without denial or delay, and the 14th Amendment, due process. At all times, a judge should be impartial and fair according to Ohio Code of Judicial Conduct Rule 2.2a. Refrain from bias actions according to Ohio Code of Judicial Conduct Rule 2.3a, b, and ensure that all parties are given the right to be heard according to Ohio Code of Judicial Conduct Rule 2.6a. 8. Conclusion. As of this filing, the codified ordinance of the City of Cleveland Heights, Ohio, Chapter 1329 remain in force, as the valid and proper way to transfer real estate. Thousands of owners in Cleveland Heights for decades have abided by Chapter 1329 to transfer their property for decades. By obtaining the city approval for transfer, it releases the property to transfer and obtain a new enforceable mortgage. Attorney Gurchik knew or should have known the transfer was void, yet presented the court with a stack of loan documents, executed by Ms. Israel with the exception of the executed acknowledgement form and city approval for transfer. The missing documents voided the transfer and made the mortgage not enforceable. UWM was made aware of the missing documents in or around March 2020 and transferred the loan to CMS. CMS cannot legally foreclose on a property they never legally acquired. CMS was notified July 2023 via telephone prior to the transfer in August 2023 by Ms. Israel that this was a possible mortgage fraud. They were aware the title may have possible defect and accepted the loan to service. Everyone involved in the transfer and new loan were now subjected to penalties, violations, lawsuits, and possible prison time. It was decided early on that Ms. Israel would be forced to sell the property back to an investor or take the fall via a foreclosure based on the events that transpired over the years and to this present day. The trial court ignored all the evidence Ms. Israel presented and deprived her to be heard at the default judgment hearing. CMS and attorney Gurchik filed a bad faith foreclosure knowing it was a fraud, intentionally failed to notify Ms. Israel to obtain a quick default judgment without proper notification, and a high possibility CMS would file a claim with the VA for over $60,000. Cuyahoga County foreclosure docket has a number of questionable default judgments against pro-SE litigants who failed to be located or answer when served. CMS and their legal team decided not to properly notify Ms. Israel because they knew she would respond. Ms. Israel was blackballed by lawyers in the state of Ohio to force her to sell the property. Lawyers informed Ms. Israel she had a very strong case against all those involved. Unfortunate for her, lawyers claimed they had a conflict of interest with the parties involved and could not represent her. Her internet service was unstable for years to keep her from researching and filing complaints while in Ohio. Ms. Israel was in Flagstaff, Arizona on January 08, 2020. Ms. Speed emailed Ms. Israel a loop that contained the purchase offer. There were no acknowledgement form or POSI included on January 08, 2020. The transfer was a VOID for failure to comply with 1329.01a, in order to permit the escrow agent to comply. Hence the escrow agent could not do their job, which is transfer the title to obtain an enforceable mortgage. As far as 2591 Lee Road, Cleveland Heights, Ohio 44118, JJ Real Estate Solutions LLC is the legal owner of the property, as the title was defected and did not transfer to Princess Ada Israel or, if any, her unknown spouse, to obtain an enforceable mortgage. In addition, The Johnsons, a team of a realtor and house flipper, were informed by the city, in a compliance letter on December 30, 2019 that they must show prospective buyers the POSI and obtain an executed receipt. The 2019 POSI documents and other related documents are published on www.2591leroad.com. On January 08, 2020 a purchase offer was presented to JJ Real Estate Solutions, LLC. 9 days later they intentionally concealed the required documents, cashed and dispersed the check for $232,500 because no one in the area with a copy of the POSI would have offered more than $125,000, with the plethora of major repairs, atrocious wildlife infestation and disturbing nuisance of daily, on the hour, every 15 minutes, blaring church bells unless of course they were an animal hoarder. They would have paid more, to be in the midst of an infestation of lab-grown skunks, possums, raccoons and groundhogs. Ms. Israel, a single, Hebrew woman of color, disabled, war veteran, has presented the appeals court with possible errors to make appropriate actions. This right here, were officers of the court, who allegedly displayed unimaginable levels of hate, and more hate with their actions. Extracted more pain and suffering upon a human being at their most unfortunate vulnerable time that CMS orchestrated, manufactured, and set in motion with calculated destructive moves since August 2023 to push a human being over the edge to gain avoided title, by any means possible, while manufacturing the appearance of foreclosure, due to missed payment, when in fact it was a fraud violations upon violations and extreme housing discrimination. All this dung upon dung, professionals across the nation have placed their livelihood on the line, exposed on websites, all because Mrs. Jenna and Mr. Jeremiah Johnson, owners of JJ Real Estate Solutions, LLC, a licensed realtor and house flipper, concealed the POSI, made a bad investment, knew the property was an infested dump. Instead of taking their losses of $100,000, they stole almost $250,000 from a disabled war veteran, pulled innocent people and businesses into their housing scheme, with no shame in their game. The default judgment is void or voidable due to fundamental due process violations and fraud on the court. The attorney filed a fraudulent affidavit/publication to obtain a false default judgment and must be vacated. Lack of proper service for an out-of-state defendant, fraud on the court, denial of opportunity to be heard, and predatory lending/foreclosure practices are a few valid reasons why the default judgment is void. Ms. Israel is not a lawyer. The mind-numbing adverse actions, collectively, by Logs Legal Group, LLP, Tamara E. Gurchik, 009-0798, Christopher G. Phillips, 007-4249, Matthew Maitland, 008-290, Edward John Delp 4, 008-8641, Magistrate Amy R. Jackson, and supervised by Judge Cassandra Collier Williams, were egregious unethical acts of alleged judicial misconduct with diabolical undertones, towards a pro-se litigant who chose to fight this beast of injustice for her retirement home that was stolen by vicious wolves, posing in sheep's clothing, that lured her from California, with the intent to defraud and deprive her of her property and earned military entitlement. Relief requested from the appeals court is reversal of default judgment, remand for new proceedings before a different judge/magistrate, and any such just actions. Relief from CMS is to withdraw the foreclosure complaint, void the mortgage, remove adverse late payments/foreclosure from Ms. Israel's credit reports, and mediation for settlement. Respectfully submitted. Underscore 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 underscore. Princess Ada Israel, Pro SE, 4364 Western Center Boulevard, Suite 5077, Fort Worth, Texas 76137. 303-552-3777, 2591leroad@gmail.com. 9. Certificate of Service. A copy of the foregoing brief was sent pursuant to App.R13 by United States Postal Service's regular mail on October 21, 2025 to Tamara Gurick, 4805 Montgomery Road, Suite 320 Norwood, Ohio 45212. Underscore 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 on. Princess Ada Israel, Pro SE. 4364 Western Center Boulevard, Suite 5077. Fort Worth, Texas 76137. 303-552-3777. 2591leeroad@gmail.com. X Appendix. 2019 Point of Sale Inspection 2591 Lee Road, 13. Acknowledgement Form JJ Real Estate Solutions LLC 07/29/2019, 15. Affidavit for Princess Ada Israel August 19, 2024, 12. Blank Acknowledgement Form City gave Ms. Israel 07/25/2020, 31. City of Cleveland Heights Approval for Transfer 07/30/2019, 15. City of Cleveland Heights Notified Sellers 12/30/2019, 14. CCCP Docket CV 24-994394-8,9. CCCP Docket CV 24-999054, 10. Civil Case Summary Inactive 07/03/2025, 9. Default Judgment 12/18/2024, 9. Email Attorney Kara Zainik Ms. Israel responded 02/14/2024, 10. Email Inactive Case 07/03/2025, 9. Letter sent to Livingston, Texas 07/14/2024, 10. Order adopting decision 07/03/2025, 9. Title Company requested transfer 07/24/2019, 15.